Hi guys, it's Kathy. Hope you're doing well. Hope you're ready for the storm. We went to the grocery store yesterday. Empty. Completely empty. Not one piece of bread. That's not true. There was the whole stack of gluten-free bread is still available. And there was some pita bread that's still available. But I have bread, so I didn't need bread. We were able to get milk. That was a big one. But who's Judge Fleischer? Bill? Bill, can you call up Judge Fleischer and ask him if he could start streaming again? Bill, how did you get a wrench? All right, guys. Does anybody need anything before the storm? Is there anybody out there who's in a pickle right now because of this storm that needs anything, that's a little desperate right now because of this storm? If there is, just go into Discord. Go into Wine Away tab and let us know if you're like, this might be really bad for me. And let us know if you need anything. All right? But the storm is going to come and then it's going to go. And we'll be fine. It's just Texas that won't be. It's just poor Texas that won't be fine. But let's see. We have, I think, guys, I have no idea which state this is. I'm going out on a limb and I'm going to say Ohio. And then you guys can tell me if I'm wrong. Is that Ohio?
We'll go on the record in People versus Eric Lewis. This is file number 255493. The record should reflect that Mr. Lewis is present here in the courtroom today. If I could have counsel for the appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thomas on behalf of the defendant, Eric Lewis.
Thank you. This is the date and time set for sentencing in this matter. Mr. Lewis, have you had an opportunity to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes, I have, Your Honor.
Mr. Thompson, are there any additions, deletions, or corrections to that report?
Your Honor, what I would say is when I allocute, Mr. Lewis has a lot of, or has things he wants the court to be aware of regarding the context of the PSI, the technical corrections or deletions, but we are commenting extensively on the PSI for my allocution.
Okay. Are there any challenges to the scoring of the guidelines?
No challenges to scoring, Your Honor.
Let's hope that the people have any additions, deletions, or corrections.
No,
Any challenges to the scoring?
no, I believe it's scored accurately.
Anything on behalf of the people for allocation?
Your Honor, I think the court is probably pretty familiar with Mr. Lewis's behavior through the PSI. Most things are documented. Honestly, he's 34 years old. This is, I think, his 9th and 10th felony. He's got 4 misdemeanors and a juvenile record. He's currently under sentence. He is literally his own worst enemy. He can present normal and he can present appropriate, and then he can be completely out of control. I did read his thing from CMH that he has voluntarily went there 18 times and wants to continue those services. I think that's great for him. But if he doesn't learn some self-control, he's going to spend the rest of his life in prison. The guidelines are 7 to 28. He doesn't get any credit because of his current situation. I don't think he's earned the bottom end of the guidelines. I would ask the court to sentence him in the middle. Thank you.
First, if I could approach, Your Honor, Prosecutor Koch referred to it, but this is a letter from CMH that does describe his attendance and his willingness to participate in that CMH counseling he received here.
Okay, thank you. I've had a chance to review that here today. Anything else you wanted to say on behalf of Mr. Lewis?
Yeah, I had several things, Your Honor. Mr. Lewis wanted the court to know, obviously looking at his record, the number of felonies, there's only 4 adult felonies before here today. Mr. Lewis had an extensive juvenile record that led to him sort of unprecedented in my experience, being sent to prison at 14. Really kind of a dramatic story when you read his PSI in terms of how long he had been incarcerated, what he got exposed to at a very young age in terms of adult, in terms of a prison. In his time, he did do a lot of additional programming that's referred to in the PSI, doing classes on advanced substance abuse, doing some classes on trying to get qualified as a janitor. As he had been out on parole here, he didn't have any formal violations. He did advocate to try to receive more services and benefits when he was here because he very much believes he needs additional help to become a functioning member of society, as he tells me a lot. He really has a lot of desires in that. He was making moves to achieve that. He wanted an apartment. He wanted to go to college. He was working towards enrolling in college. He wanted to have a productive life. Unfortunately, he had a very bad day here. It wasn't an aggressive thing. It was a non-compliance thing. He wasn't intoxicated that day. He was sent to jail. At some points, and I've watched hours of videos about this day. At points he does submit. He submitted handcuffing. He didn't attack officers, but there were points where he was not compliant. He advises me he was very sick that day. He'd been sick for a while. That caused him to go off his medication. He couldn't bail it down. That caused him to go off his mental health medications, and so he wasn't in his best state that day. There are times when it's referred to that he was in a fighting stance. He really doesn't agree with that. And I've watched the video, and his hands were at his side. It's a very aggressive posture from his perspective. He's getting about ready to be tased, so he's tensing up. But he wants the court to know he didn't raise his hands in an aggressive way. He had them at his side, but he was tensing up because he was about to get tased, and he ultimately was tased. Ultimately that day, he's the person who got hurt. He's the person who bore that burden on that day. He knows he really needs help. I think he's demonstrated a lot of insight into that. He knows he needs mental health counseling, and the court can see he's participated with CMH. He has a brother who's doing very well in Gaylord. He looks towards that in terms of a family member who has been able to do the things he wants to do. He did get a GED in 2007. He does suffer from mental health concerns. I think at some points it refers to his health as being in good health, but he wants the court to know he does suffer from PTSD, anxiety, depression, perhaps ODD. He was married and then divorced. In his background, yes, I wasn't clear about that. Mr. Lewis presents, as someone with a very difficult record, and I don't know that it's necessarily untrue that he is his own worst enemy, but he wants the court to consider a community sanction of jail time up to the 12 months. That would be appropriate. Allow him to continue to try to work on the things he's trying to work on. Thank you.
Mr. Lewis, anything you wanted to say today?
Everything my lawyer has said is accurate. I do have like mental issues or whatever, and I understand this. Like when I'm I guess faced with somebody that is talking aggressively towards me, I tend to match their energy because of the things I've been through and where I just came from. I did almost 10 years in a level 4 prison out of the almost 12 that I just did. So like, you got to understand, being a white guy and a smaller white guy in a level 4 prison does tend to, reflect on you because of how long it was, you know what I mean? And I don't mean to be like that. And I have been steadily trying to change this. And as you can see, like through everything I've actually did accomplish when I was out there, I was actually trying to do normal stuff. I wasn't doing drugs or nothing like that. I did smoke weed and I did occasionally drink, and my parole officer did know about this. And I'm not a liar, so, you know, I was always straightforward with him. And I took my medications, and like I told you the last time I was in here, when they came in, I was sick. I was real sick, and you can verify that through the jail stuff. Because I didn't eat for almost a week or something like that. I just kept puking. And like I was on like cough med, like all that, you know, NyQuil, DayQuil, Courtesy and stuff. You don't get that in prison. So like that was all new to me. You know, you don't get any type of, you know, narcotics, so to speak, like that. And then being off my meds, you know, I was real highly emotional and stuff like that. You'll see in the video, if you watch the video, that I was sleeping. I was complying up to the whole time. And like I said, I don't even know why I said I ain't saying shit when they told me to send the chair. It didn't even make sense. At first, I thought it was just literally like a typo or something. And then when I seen the video, I'm like, damn, why did I say that? They don't, you know what I mean? Like, I'm complying up to this point. Why would I be like that? And then they try to force me into the chair. And I don't know. I wasn't in the right state of mind. I ended up apologizing to one of the cops, a younger guy, for it. And I told him, man, that's my bad. You know, like I'm trying to do right. I had a job out there. I was about to start college, and on November 4th, all I had to do was the FAFSA and just waiting on the time to file the FAFSA. But everything else was already in line. I was going to go for business and entrepreneurship. I was about to start an LLC and try to do like that resale stuff, you know, to get a little bit of a side hustle going on. I was looking for a second job. I bought a bunch of stuff for the place I was living at, which is all gone now, but I bought a bunch of stuff. Like I was on the right track. You know what I mean? And like my next step was either to get my own place, which I was talking to Todd about, which was like the coordinator guy or whatever, and or get a car. You know what I mean? And another thing was like in 2023, you know, I had a bad seizure that like left me like I flatlined all the way through, you know, like they was about to pull the plug on me and everything. And they said, I'm a medical miracle that I should even be talking here today. And like, that messed up my mind a little bit, like, you know, thinking wise and stuff like that. And it's not an excuse, you know, this is documented through Sparrow Hospital. This is all stuff that can be checked into. And like, that's kind of why I'm on Capra and stuff like that to help straighten myself out. I'm just trying to get, you know, a second chance, man. I'm trying to do the right thing. I don't want nothing to do with prison. I don't want nothing to do with getting in trouble. You know, I don't want nothing to do with none of that. Your Honor, I even, when I was out there, I called the cops a couple times, you know, just to show like I was trying to change. I even talked to John about a couple things that happened because I didn't know what to do. I've never called the cops on nobody before. So I was trying to actually be a productive member. You know what I mean? Like I you know, never done this, and I didn't really have any help. And everything that I was reading was I was supposed to get help. And then I didn't get no help. I got a place to stay. And then the first 3 days, the toilet didn't even flush, you know, and like, and I didn't, everything I bought was with my own will, you know, with my own doing. So, you know, and you can see like all the stuff that was in my apartment, like I got all that, you know, nobody else there in that phase motel had nowhere near as much stuff as I had. You can tell I wasn't doing drugs, you know, and I don't really know what else to say. Like I was trying, you know, it was just a bad day. I was sick. You know, I apologize to the court. I apologize to the cops mainly for even acting like that. Like I feel stupid acting like that. I don't even like acting like that. Like I play around, I joke and stuff like that. But you know, but that's with like people that you know I'm comfortable with. You know, but other than that, dude, I don't talk to people like that. I talk to people with respect. You know, some type of intelligence. I don't like to do that. I've never came out of my bag with John that I can remember. I don't even think we've even had a bad conversation. You know, and I don't know. John's never done me wrong. I've never done him wrong. He's always been straightforward with me, and I've always been straightforward with him. Blatant to the point. You know, like at one point in time, I give you an example. At one point in time, I had like a little. It was kind of like a pocket knife thing or whatever, and I was using it to cut boxes up at my work, like cutting them open and stuff. Because I worked at Bears Den, so I cut plastic open. It was real small. It was like the size of a razor blade. And John said I'd get in trouble for it, so I ended up throwing it away just because I didn't want to get in trouble for it. You know what I mean? Like I don't even have like anything that he said I'd get in trouble for, I just didn't do. You know, I was actually trying.
Okay, Well, I did read through the report, so I'm familiar with the incident that brings you before the court here today. I read through the report that contains all the background information about you, your circumstances, your past history, your medical issues and so forth. So I have all that information. I take all of that into account along with what the lawyers had to say, and I listened very carefully to everything that you've had to say here. First of all, I think make a really valid point that you have had a lot of negative experiences based on your prior incarceration. I think it's completely understandable that somebody who's had to deal with what you've had to deal with and live the way that you've had to live in prison and the things that you've had to do to defend yourself and keep yourself safe and secure in that environment. You can't just switch that off when you're outside of it. And that, when you're faced with certain situations, that background is going to tend to cause you to have an reaction and things that a normal person who hasn't been through those things wouldn't do. And so, I think that's completely, again, understandable that you would react in that way. The problem is those officers don't necessarily know what your background is. They're responding to a situation and they have to deal with somebody who's doing the kind of things that you were doing. And because you've had that background in your life doesn't necessarily give you the right to put them in a position.
No, it doesn't. I understand that.
So, and I say that because I think that's a mitigating factor, but it's not one that excuses your behavior in this case.
No.
And so that's one thing. I think what's positive is that you are taking steps through community mental health to address those things so that you can work on strategies to help you react in a different way than you did in this situation because of your background. And I think that's a big key for you going forward as to whether or not you're going to spend more time on the outside or more time on the inside.
Yeah, I agree.
So I say that because I think that's something that I should take into consideration in terms of sentence. As you're aware, your guidelines are 7 to 28 months. I think your conduct in this case and your past history would certainly warrant a sentence at the high end of the range. I think the fact that you are addressing some of those issues and have voluntarily participated in community mental health gives the court reason to believe that there is potential for rehabilitation and that it's something that you're self-directing as opposed to being ordered to do it, which I think makes a difference as well. And so in my mind, that moves the sentence from one that's at the top end of the guidelines to one that's more in the middle, because I think that sentence in the middle of the guidelines addresses the positive things that you're doing, but it also addresses the wrongfulness of your conduct in this case. So the court finds that the sentence of 18 months in the Michigan Department of Corrections to 3 years as to each count is a reasonable and fair sentence given all the circumstances in this case. Because of your parole status, you do have credit for 0 days served. Any sentence here is required to be consecutive to any parole violations. Court will order a crime victim assessment of $130, court costs $325, attorney fees $50, and $136 state costs. You have the ability to seek an appeal of the sentence. Appellate rights. Did you want this?
Yes, please. These are your forms if you want to file an appeal. There's 4 copies. You're going to initial the top one to indicate that you've received it. You're going to keep the bottom 2 if you want to file an appeal. One of the deadlines is 14 days. So you have to fill those out and turn them in within 14 days. Say the 7th, Your Honor.
It was emailed.
You can email it and attach it.
I look for it.
All right, so you keep those copies. You can fill those out if you will type them if you want to file that appeal.
18 months for having a fit with the police. 18 months for that one day. Probably took 10 minutes for the whole incident, and he's going back for 18 months.
Counsel and Mr. Clark themselves. So the court will call People versus Caleb Clark. We have two files, 255442, 5506. Record should reflect Mr. Clark present here in the courtroom today. Mr. Clark, did you have an opportunity to go through the report about that?
Yes.
Mr. Thompson, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Pope, any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for help?
I'm actually really glad that Mr. Clark sat through the last sentencing because I think that it's good for him to understand his history is really bad. He's had a pretty tough go of it throughout the last couple of years we've been dealing with him. And when he talks, he doesn't seem aggressive. And then you see these behaviors in the jail, and it's almost as if he doesn't want to get out of jail. It looks like he doesn't want to get out of jail. He just wants to stay in jail. And now he's moving on, and he's, 19 years old, and now he's looking at prison. And then, if he gets out of prison or he gets out of jail, whatever the court sentences him today, he's going to his guidelines are just going to keep going up and up and up. He doesn't have a lot of self-control in the jail. And for him to act the way he did in this case and put people in danger is completely inappropriate. And if he just wants to continue this path, he's just going to stay in institutions until he's completely institutionalized, which is really sad for a 19-year-old. So I hope that, this is the last time that we see Mr. Clark. I hope that the court sentences him within the guidelines. He doesn't have very much criminal history as an adult because he's only 19 years old. He's putting people in danger. If he can keep his head down and maybe get some help for his anger management and his behavior, maybe he can get on the right path. So I'd ask the court to follow the recommendation. Thank you.
Thank you, Your Honor. I do agree there's some sort of parallels to, unfortunately, Mr. Lewis being incarcerated for a long time and how Mr. Clark's adulthood is starting out. I really like Mr. Clark. He's 19. We have very positive interactions. I really enjoy talking to him. I really think he has a lot of potential. I think he has a lot of intelligence. I think he's pretty clearly on some sort of spectrum. He doesn't always express things the way a normal person does. And I think that's one of the really interesting and unique things about him. But that's what I see happening when he's losing control in the jail. He did advise and did confide in me that he had been assaulted while he was at the Wayne County Juvenile Facility. And that's part of why he has such he's capable of reacting so negatively when something bad happens, when he is incarcerated and things are not going well. It's really too bad that triggers because he was on track to, be released here. More than any client probably I've had in recent memory, Mr. Clark is kind of on his own, working through foster care. He essentially had to stay in Michigan as a guardian. Now into adulthood, he has an adult guardian. And again, it's someone from the state. He doesn't have family support. It's really too bad. He is in line. If and when he does get released, he's probably going to need to end up being in an AFC home.
They didn't specifically say what the charge was, but I do know that, or I wasn't paying attention. It was because of a prison fight, or the way he acted towards guards in a prison, I should say.
I talked to Caleb about boot camp. He's really excited about it. I think that is a really good alternative for him. I don't know that a 19-year-old doing long-term, months in the Crawford County Jail, I don't know that he's able to fulfill his potential in there. I think boot camp would be a really good chance for him to use some of that 19-year-old energy to try and grow and try and develop. So I really do think he's someone with a lot of potential, and I really do have high hopes for him, and I hope the court will sort of see him as that whole picture in terms of his background and what he's been through. Nobody's excusing what he did. It's really unfortunate that happened. I know Caleb feels bad about it, and I hope he takes the opportunity to apologize for it. Thank you.
Thank you, Mr. Clark. Was there anything you wanted to say today? The record should reflect Mr. Clark. I was shaking his head no. Mr. Clark, I did read through the pre-sentence report. You've been in front of me before on a different case, the probation case that we can talk about in a second. So I'm well familiar with your background and your history. And through that report, what happened in this case. And I agree with Mr. Thompson that it's really unfortunate. You haven't had much of a safety net in your life to help you to teach you the right way. And I think that in addition to probably some mental issues that are something that are have developed over time, or you were just born with, have all combined create a situation where you act out in ways that are out of control. It's unfortunate that we don't have a mechanism that can better deal with those kind of issues. Complicating factor is that you get violent, and so the number one priority for the court and the community is to have to make sure that everybody else is safe when you act out. That means, unfortunately, having some tighter controls on you, which I think contributes to the problem rather than solving it. But don't have any other good help. Again, of course, the safety of others is a primary concern. So, I'm presents everything to yourself and to others. Reactive. In terms of the recommendations here, I do think that they're appropriate. It sounds like you may be eligible for the boot camp program. If you are, that's something I certainly would consider for somebody at your age as an intervention. Maybe try to interrupt the cycle that you're in. And so that's something the court certainly would consider. You're a young man, and I'm not going to sentence you at the top end of the guidelines primarily for that purpose. Because of your age, I still have people for some rehabilitation here. But at the same time, I think there needs to be a significant penalty here. The guidelines in this case are up to 29 months, 2 months. One to 17, the other 14 to 29. So the court finds it a sentence of on the charge of the assault of behavior, the 14 to 29 charge, the court finds that an appropriate sentence would be 24 months to 5 years. As to the R&O charge, the court finds that an appropriate sentence would be 17 months to 2 years. I'm sorry, 16 months to 2 years. You have credits for 92 days served. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, $68 state cost as count one, as count four, a $68 state cost. You have the ability to seek an appeal of the sentence, and Mr. Thompson can provide those color rates.
You can initial copy for me. Fill that out, kite it out, and we'll start the appeal process.
that's all.
Your Honor, we have his probation violation up too. Could we just discharge him unsuccessfully and dismiss the probation violation?
Address that. Thank you.
Thank you, Your Honor. Prepare that order.
Okay, Mr. Walt, if you'd like to come forward to the podium, please. The court will call People versus Dwayne Walt, file number 255477, right up here. Oh, do you have a problem with your foot?
Yeah,
can
that's
sit if
okay.
you want.
It's okay.
If it's gonna cause you distress.
I'm okay.
All right, if I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Walt.
Okay. The record should reflect that Mr. Walt's present here in the courtroom today. This is the date and time set for a sentencing hearing. Mr. Walt, did you have an opportunity to go through the pre-sentence report?
We did. We did.
Mr. Trush, are there any additions, deletions, or corrections to that report?
The only correction that I would make to the report is the adult criminal history section entry entry 16 of 16 is a Clare County case. It indicates that it's pending. I believe that's been resolved and he served his sentence. I think he was released from Clare County's jail yesterday.
Or yesterday, yes. Okay, Ms. Coke, do you have any objection to that correction or update, I guess, more like?
No.
Okay. Do you need any more information than that, Mr.?
Well, just like the final charge.
Well, it's 2 attempted RNOs,
Okay.
which I agreed on. I was in jail for 73 days.
What is that? What they gave you 73 days?
73 days, no more time served when I went to jail, and then I'm on 9 months probation now. So they did put me on probation. So I don't know if that.
All right. Gotcha.
I didn't think that was coming. I didn't see that coming at all, but as it stands now, I am on probation. So if there's a thought about that at all with sentencing, okay, there's a consideration to be done there, then I would appreciate it, but that's all I have to say.
All right. Mr. Trush, any other corrections?
No, Your Honor.
Any other challenges to the scoring of the guidelines?
No.
Anything on behalf of the people for allocution today? Or I'm sorry, got ahead of myself. Ms. Coke, do you have any additions, deletions, or corrections?
No.
Do you have any challenges to the scoring?
No, I just want to confirm his bond was not canceled. So my notes say 9 days credit. I don't know if, I'm not sure if there's additional credit because of the Claire thing that we didn't know or not. I just want to make sure
I
anyone.
have 9 as well.
Okay.
I
Thank
think
you.
9 is correct.
One thing you can be sure of, no matter how shitty the audio is in a courtroom, you can always hear the papers being lightly touched, barely.
Yeah, because we didn't- if I may.
You can, I'm going to give you a chance to say whatever
And
you
the
want in a
stamps,
second.
and the staplers,
Let me have everybody else take their.
and the coughing.
Ms. Coke, anything you wanted to say for allocution?
Your Honor, Mr. Walt presents, he's 43. He's got 11 misdemeanors and 3 felonies. He's had a series of issues recently. I know he's had some medical issues. I have notes from our November hearing that he was in the Clare jail and had a bone marrow disease. We discussed revoking his bond, but the reason, and this is why I asked the court, the reason we didn't revoke his bond at that time is they said that if we revoked his bond and they were going to release him for treatment, which they didn't know at the time to do the bone marrow treatment, if we revoked his bond, then he would just come here instead of go to the bone marrow medical treatment. So if we didn't revoke his bond, that's why we discussed it on the record at length at that court. And I just want the court to know that's what happened and why he didn't end up getting that credit for the time that was served because of his bone marrow disease. The recommendation is 60 days with 9 days credit. It may be appropriate for the court to take into take into consideration some of that credit that he would have got if he didn't have that. Because we weren't really sure what was going to happen with the Clare County Jail. But I defer to the court and thank you.
Thank you, Your Honor. I think what the prosecutor outlined here is accurate. And I mean that she identified at the last hearing, there was discussion of canceling his bond. We ultimately didn't ask the court to cancel it because we didn't want to put him in a position where if he needed to be released for treatment, we had to scramble and try to do something in order for him to be able to get medical attention that he needed. So I would suggest to the court, the recommendation here is 60 days. He's just finished serving a 73-day sentence in Clare County. Again, was literally released yesterday. He's on probation to Clare County. I would suggest to the court, I don't think he's entitled to credit for that time, but I also don't think the court has to turn a blind eye to the facts of the situation here, which is he just served a jail sentence commiserate with what's recommended here. I would suggest to the court, deviating from this a little bit would make sense to me in terms of placing him on a probation that mirrors the probation, in Clare County. I think that's an appropriate way to handle it, and it takes into account Mr. Walt's unique circumstances. Thank you.
All right, thank you, Mr. Walt. Anything you want to say?
Well, I just wanted to say, I'm truly apologize for the situation that I'm in right now. To be honest, and it sounds funny, but I got gray hairs on my chin now, and it really affected me. Like it sounds simple and stupid, but it really means a lot to me. I think I finally got it. I think I finally figured it out. What's more important in life, my wife's gonna take me back. My kid misses me so much. He's just been so wonderful the last 2 days. So I apologize for anything, and I feel like I've done a lot of growing up, considering I sat in jail for something I didn't do, and I took that as a blessing. It was a blessing in disguise for me because it saved me a lot. So that's really all I have to say. Thank you.
All right, I did read through the pre-sentence report, so familiar with why you're before the court here today, the circumstances of this offense. There's also a lot of information in that report about you, the background and circumstances as well. You have a lot of factors working against you at this point. You've developed a relatively lengthy criminal history, and to the extent that you're saying that you're tired of this, now is the time, because your guidelines are only going to go further up, and you're going to end up spending time in prison. It looks like so far, been there once. Yeah, you got 7 probations, 6 jail, 1 prison sentence. So sooner or later, whether it's me or a different judge is going to look at that and say, we're done with probation, we're done with jail, there's no point to that anymore, because none of it's worked. So to the extent you're going to make a change now is the time to do it. In terms of this offense, it's not a particularly serious offense. You had a relatively small amount that appears that it was a personal use amount. So there's no indication of trafficking or that type of thing here, which would call for a more serious penalty. I do think it's appropriate to take into account the time that you served in Clare County, that had your bond been canceled here, it would have essentially subsumed or perhaps even more or close to the 60-day sentence that the court would impose here. The guidelines are 0 to 17. Taking all things into consideration, the court is not going to impose any additional jail time here today above 9 years served at the time you served at Clare.
So the first 2, they both got 18 months or whatever for jail. They're gone. They're in jail. Well, the other, he's still sitting there, but this guy walks up and tells the judge, I got gray hairs on my chin. It really affected me. No jail for you. He didn't get any jail. but the other guys really, theirs were more violent. They were fighting with police and guards. This guy had some sort of drug on him. So, all right, we're gonna move on now. Watch your ears, because I went through all the rest of the clips, and I pumped up the sound. Let's go this one.
203-25-02654, 25-01514, 25-01606. Appearance, please.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Polito. At this time, he has applied for the Public Defender's office, and I would enter a not guilty plea on his behalf for each of the files.
Hi, Mr. Polito. Hello, sir. Good news for you, Monica.
Okay. Okay. Mr. Polito.
Yes,
You are
ma'am.
Frank Polito, correct?
Yes, ma'am.
Okay, Mr. Polito, I have here, I just did that upside down, in file number 26-00203, a felony file with a complaint that alleges that you committed the act in count 1 of controlled substance possession of methamphetamine or ecstasy, and that on or about January 20th, 2026 at 12:15 East Michigan Ave, Lansing, Michigan, that you did knowingly or intentionally possess methamphetamine contrary to MCL 333.74032 VI. That's a felony with a maximum penalty of 10 years in prison and or $15,000. There's a count 2 of police officer assault, resist, obstruct. The allegation are that on or about the same date at the same location of 12:15 East Michigan Ave, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Mark Fox, a police officer of the Lansing Police Department the defendant knew or had reason to know was performing his or her duties contrary to MCL 750.81D1. That is a felony, maximum penalty 2 years and or $2,000 in fines. A consecutive sentence may be imposed if the assault was committed in a place of confinement.
They're the ones that hit me.
Mr. Polito, I'm going to advise you to use your right to remain silent here.
But they hit me like 5
Mr.
times.
Polito, I would
didn't
not
touch
advise
them.
saying anything further at this stage.
That's fucked up.
Excuse me?
I said it's fucked up
No,
that they're the ones that
Don't swear in my court.
Alright.
Because you have a right to remain silent. You could just close your mouth as your attorney has advised you to do.
I mean, I'm not yelling with you. I mean, I'm just saying.
I don't
they
care.
hit-
I don't want to hear your profane language either.
Alright, I'm sorry, I swore, but I got beat up last night for no reason.
Okay,
By
that
these
sounds like
officers.
it's part of your defense, but your attorney, and maybe you don't understand. The reason why maybe your attorney doesn't want you to say anything on a record that could be used against you is because you have the right to have the prosecutor have to prove each element, including that it was actually you present at that location. She doesn't want you giving the prosecutor any of the evidence by opening your mouth.
Alright, thank you.
Okay, I have file number 25-02654, which is another hinder, obstruct, oppose an officer. The allegations in this file. No, what's the matter with this complaint? Allegations in this file are that on or about June 20th, 2025. That you allegedly at the area of 2400 East Kalamazoo, City of Lansing, did hinder, oppose, obstruct, or resist the officer in the performance of law enforcement duties at that area, and that this was contrary to the provisions of the Code of Lansing, being 602.02, and that's a maximum penalty 90 days in jail and or $500 in fines. Do you understand the charges there and the maximum penalty?
Yeah.
Okay, let's see, did we miss anything? Actually, we probably was already ready to go.
I forgot one. We can also hear keyboards when we can't hear anything else in the courtroom. We can hear typing.
It's not.
Mouse
Okay.
clicks.
Okay, you have the right in each of these matters to be represented by an attorney. Ms. Sutter is attempting to represent you today for the purpose of your arraignment. But you have the right to have an attorney that will represent you at all of your court appearances, which this is one of them, as well as if you're questioned by law enforcement. If you can't afford to hire an attorney, you can request to have the public defender's office represent you at the expense of the public. Do you understand those rights? I don't know if he responded. I can't hear anything.
I thought I heard yeah, Your Honor, but I'm not positive.
Mr. Polito,
But
did you say what?
yeah, I said
Did you hear
yeah.
me ask you? Did you hear me ask you? Are you unable to stand on your own? Is that why you're leaning up against the wall?
I'm fucking pissed, so I'm leaning against the wall.
Well, you stand up.
I got charges there. I got charges there.
Yeah. If you can't control yourself for us to work through this, that's okay. We can set this till tomorrow and then give you some time to calm down.
Yeah, let's do that. Let me go calm down real fast.
Wonderful. Let me remand you to tomorrow and then you'll see the magistrate off the record.
Dumbass.
All forwarded on his application to tomorrow's attorney, Your Honor.
Thank you.
How not to act in court. All right. We're going back to Michigan again real quick for this guy. He's got a story. He eventually has a story.
Mr. Trush, are you able to hear me okay?
Yes, Your Honor.
All right, we're on the record now in People versus Joseph Poyer, file number 2554171. The record should reflect Mr. Poyer is present here before the court today. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Fuchs on behalf of Mr. Poyer.
Thank you. We're on the record today. We did have a hearing previously scheduled in November. Mr. Poyer failed to appear for that hearing. The court issued a bench warrant. He was apprehended on that bench warrant in late December and has been lodged since that time. The court set this for a status conference today to address that as well as any bond going forward. Mr. Trush, can you tell me the status of this file here today?
So, Your Honor, I've had discussions with Mr. Poyer about this file. Unfortunately, I mean, he hasn't made his intentions on how he wants to proceed completely clear. I've discussed with him what the offer is. And I mean, what he repeatedly will tell me is that what he wants to do is get mental health treatment and get treatment for his mental health, which frankly, I think is a good idea. I think that is something that he needs to address, and I think it's something that permeates the case. However, it doesn't completely answer the question of how does he want to address the matter. I certainly think that there are options in terms of mental health treatment that can have an impact on how the case goes. I've discussed with him things like mental health treatment courts. I've discussed with him things like jail diversion programs through CMH. But I'm not sure that we're zeroed in and completely dialed in on how it is that we want to, resolve the case ultimately. In terms of bond, I would suggest to the court, Mr. Poyer has been in contact with me in my office consistently. He expressed to me, he suffers from a variety of different mental health issues. He's given me psychological evaluations that he's had done in the past, which outlines some of these issues, and expressed to me concerns, about the hearing, expressing to me that he has agoraphobia. In fairness and in candor to the court, I don't have a specific diagnosis of that yet, and I don't know if there is one out there. But again, he certainly is diagnosed with anxiety disorders, and a variety of other maladies. So it would not surprise me. But again, I can't in good conscience tell the court I have a diagnosis of that, of agoraphobia at this point. So I guess in terms of a bond, I would ask the court to set a bond that he would be able to post. Because again, I do think that the mental health issues are permeating the case. And again, he has not violated any of his bond conditions again, other than the missed court appearance, which frankly, I mean, Zoom might be a middle ground that would allow him to maintain those appearances. Thank you.
All right. What is the current plea offer, Mr. Trush?
Your Honor,
The offer is domestic violence, third offense, dismiss his habituals.
and count two.
Okay, yeah. As well as I think we offered to, he has a misdemeanor case in district court. I think we offered to dismiss that as well.
All right, so Mr. Feuer, we have to figure out how we're going to go forward with your case first. And there's two options. You can either go forward with a plea agreement or we can have this set for trial. But we need to determine the outcome of the case where I can address, if you're eventually found guilty either through plea or by a jury, then I'd be more than happy to consider, treatment and those types of things as an option for sentencing.
Thank you, Kelly. Thank you.
But
Thank
until we
you.
get to that point, there's not much that we're going to do in that regard. So we need to know from you how you want to proceed with your case.
I don't know what to do right now. I need my medication so I can even think straight. Like I'm off balance right now. Like I don't even know what's really going on. Like I just confused. I don't know. I need my medication. They won't give it to me.
Can you tell me what you're confused about?
Just everything. Like my mind just feel like I'm suffocating right now. And it's hard to process anything. I can't watch TV. I can't read. I can't do much of anything.
Okay. Mr. Trush, when was the last time you had a chance to speak with Mr. Feuer?
I had an opportunity to speak to him.
Like recently, within the last?
Yeah,
week or
I think
two?
it was. I think it was Tuesday night. And in candor, that was the first time I was aware that this was up this week. That was when I received the notice of the hearing.
Sure.
And again, I spoke to him that evening and talked to him a little bit about what the hearing was about.
During that conversation, which I'm sure is more extensive than what I've had with Mr. Feuer here in the courtroom, did that raise any concerns to you about competency? I mean, what he's indicating to me on the record is that he's having trouble understanding what's going on, not just within this case, but generally.
I haven't had concerns with competency. When I talked to him about the case, I mean, he expresses to me, reasonable ideas in terms of how to defend the case at a trial. He expresses to me and understands the difference between a plea and a trial. So I mean, candidly, my worry is I think a competency eval probably isn't going to do us a lot of good.
Okay. All right. So, Mr. Feuer, you can either plead guilty and admit guilt as to the charges under the plea agreement, or we can have this set for a trial. And if you don't know what you want to do, what my intention would be is to have this set for a trial, and then you would have time to still enter a plea after that.
All this is just me being unstable. It's not me to have any of this anymore. I don't know what to do.
Okay, so I'm going to go ahead and put this on the trial docket and set it with a plea cutoff. Ms. Cope, how much time do you need to be ready for a trial?
Because he is lodged, he's probably going to take priority. I would say we can be ready in 60 days. Our February dockets are really full. I think we have 9 felony jury trials scheduled in February. So we would ask for March or April. I will say for the record, just so the court's aware, he did fail to appear in his misdemeanor case as well. His parents indicated he had stopped his mental health treatment prior to being arrested and prior to the incident. And he has a pretty long criminal history. So if we're going to talk about bond, I'd like a chance to address that. Thank you.
Yeah, we're going to talk about that in just a second. Mr. Trush, if we set this for March or April, is that enough time for you to be prepared?
Yes, Your Honor.
Okay. And Ms. Cope, how many days of trial?
I would say we could do it in one. If defense is gonna call witnesses, we may need 2. I will probably do a 768 and 404B notice.
Mr. Trush, I'm gonna go ahead and set this for 2 days, just in case we do need extra time for picking a jury, and so forth. And then the court will set this for a final status conference and plea cutoff prior to the trial date.
Could we also have a status conference next month, just because of what Mr. Poirier said today? I don't want to have it, I mean, that'll be February. We may need 2 status conferences, but I think that'd be better in this case.
Yes. Do you have any objection to that, Mr. Trush?
No, Your Honor. My intentions was to indicate to the court. I will go over and talk to Mr. Poirier. If there is movement or a change in something, I would notify the court. So I'm fine with setting a status conference.
All right, thank you. All right, and then
Nurses aren't that hard to pick up. They're super easy. They really just want a nap. They're tired. So press your little button. Nurse, I need help. I need help. Here, lay down for just 10 minutes. No one will know. They'll think you're helping me. Just lay down. Close your eyes. You're okay. Boom. Instant nurse girlfriend.
Mr. Trush. Mr. Trush, was there anything else you wanted to say regarding bond?
No, Your Honor.
Ms. Cope?
Yeah, Mr. Poirier, and we went over this a couple of different times, has a pretty extensive violent criminal history. Some of it's missing from his CCH, but I was able to put it together through his prior PSIs. But he has a 2001 MDOP, that was a juvenile, a CSC 4 juvenile, a larceny juvenile. In 2002, he has a UDAA. In 2002, he has a flee and elude third. In 2002, he has a UDAA. He did have a domestic violence in 2004 that was dismissed, but he had a conviction for domestic violence and cutting telephone lines, it looks like. In 2006, he had an MDOB less than 200. In 2006, he had an OWI. In 2013, he had another domestic violence. In 2013, he had an aggravated stalking. In 2014, he had a malicious destruction of a building less than 200. In 2017, it looks like it was an assault by strangulation in DV2. It's a little confusing from his CCH, but it looks like he went to prison on this. His parents believe that this was the case that he went to prison for 5 years on. And that same year, he had an R&O. Looks like the sentencings were similar in date. And that's his parents had called me when this case started repeatedly. They indicated they were in fear for their life and thought that he would kill them. When he got out, he went right to their house, and I ended up talking to the bondsman. State trooper was present as well. He was getting, I think, his camper or things from his camper. I don't remember how that played out exactly, but he was there immediately upon being released. They were concerned about that. And then, he failed to appear in this case, indicated he wasn't coming because he was agoraphobic. And then in his illegal entry, he indicated the same and didn't appear for that. So I'm not sure if we release him on bond that he's going to appear again. His criminal history, as I said, is pretty violent. And the victims in this case were pretty adamant that they were concerned. He had mental health treatment, but he stopped going to it on his own prior to the incident, according to his parents, who were the victims. Thank you.
Mr. Poirier, was there anything you wanted to say regarding bond?
Yeah, I'm not a violent person.
All right, given your past history, Mr. Porter, given your failures to appear in this case and your district court case, court finds that cash or surety bond in an amount greater than your previous bond is necessary both for public safety purposes and to ensure your appearance in court. Court will set bond in the amount of $50,000 cash and surety. Court will adopt all the conditions of your earlier bond, which included no contact with Donald or Lori Queer. And so the court will continue those conditions as well. And then the next hearing date will be in February. You'll be notified of the date and time of that hearing, and you'll have an opportunity to speak with your attorney prior to that. Mr. Trush, anything else we can address for the record today on this case?
No, Your Honor, thank you.
Ms. Coe?
No, thank you.
Thank you.
Poor Mr. Trush was trying to get this case moved forward, but this guy wouldn't work with him at all. Now, this guy's standing here moaning and complaining the jail won't give him his meds. Well, he stopped taking his meds way before they put him in jail. Way before. Okay. This judge stopped streaming. I think a year ago. And I think this whole Zoom case might be one of the big reasons why she does like in person only. This is very frustrating. I was on for hours. I didn't stop checking. It was a continuous check. I just sat here and waited. But no, there's no Judge Fleischer yesterday, guys. Oh, frustration. Here we go.
Thank you. Recalling the case of Morton versus Warren Burkett, file number 22-2456 LT. Hello again, Ms. Morton.
Hi.
Did you have an opportunity to speak with the Resolution Center along with Precious Warren Burkett, the defendant?
Yeah.
Can you repeat that? Your screen froze.
Yes, I would. Is there something I'm doing?
I don't think so. It might just be where you're located in your home. Maybe going by the door or closer to a window might help.
I am at a window.
Okay. Let's try it there. Be seated.
Okay.
All right.
Can you hear me?
Yes. Is the
Can you
TV
hear
on
me?
or anything?
It might be in the side. I can go check.
Yeah, sometimes if there's other noise, then your speaker will cut you off and try to pick up the other noise in your home.
You mean like typing, paper shuffling, clicking, coughing? You think like that?
I might have had the cell phone too. Is that better?
Yes, ma'am, that is better.
Is that better?
Yes, it is.
Okay.
All right,
Thank you.
now, did you have a chance to discuss everything with your tenant and the mediation center?
Like I said, situation. And
A lot of what you're
I
saying
have-
is being cut off. Can you put your phone closer to your mouth?
is that better?
Yes,
Is
let's
that
try
better?
it now. Yes, can you begin again? You were describing what happened at mediation.
Yes, we did not come to a the problem is that my tenant is destroying my house, and I would like access to my house as soon as possible. I got from the kitchen cabinets are waterlogged.
Yes, I heard you
Hanson-
mention the water problem earlier. There is a special complaint where the landlord seeks emergency access for certain problems that can damage the property. However, you did not file your complaint that way. Your complaint is not for termination of tenancy due to an emergency damage to the property. Your complaint is for
threatening my life with a gun. That's what basically safe police officer that I come from.
your complaint is to recover possession of the property. It is not for non-payment of rent. And it's just that your complaint does not indicate that there's any emergency to it. So in that instance, when the defendant fails to appear after receiving personal service, I can issue a default judgment. My problem here today is that she did appear. I just don't know what happened to her. So I'm going to find out from my court officer if he knows. Officer Denham, do you know what happened to the defendant?
No, you know, after you sent him the mediation?
Yes. Did you see her back?
No, she never came back here.
All right. Did you speak with her in mediation, Ms. Morton?
It looks like she's frozen.
She did not.
Hold on, here she is. She just popped in.
She don't want to.
Judge, Ms. Burkett just popped in.
All right. Just a minute, Ms. Morton. Ms. Burkett, please stand by. We're going to ask Ms. Morton to disconnect and call in instead. Can you give her instructions for that, Officer Denham? Because we're not able to hear Ms. Morton on this way.
Ms. Morton.
Sitting right there with her dentures for her.
I'm
Ms.
going to send you.
Bucket.
Yes, what number?
Okay, I'm gonna see you a message, okay? It's gonna have a telephone number that you call in on.
I can't. Okay, could you phone 313-617-9548?
That would have solved everything. If they would have just listened to her right there. Just call her. Just call her. Nope, that's not what they do.
Look at, you see that message just popped up on your screen?
No, I didn't see it.
Okay, touch your screen. It's a message that popped up. It's a telephone number. You call that telephone number, then you put the ID number in.
Sir, it did not pop up. Can you give me, can you read it off to me?
646-876-9923.
687. And then what?
9923. Then they ask
Then
you
what?
for the meeting. They ask you for the meeting ID number. You put this meeting ID number in. The one you put in to get to the Zoom.
The one that I called. 6-876-9923.
Yes.
Sure. Okay. If you say so, ma'am, just call that number.
Is that right?
I'm assuming you keep going in and out. That's what you need to call.
923. In the middle. All right.
Because
Hi, Attorney Wright. Who are you representing next?
Parnell Richardson.
Is anybody coming from pallets?
I was informed that no one checked in from pallets.
Calling the
Yes.
case of rental management 1 versus Richardson, file number 22-1746 LT.
Welcome to Zoom. Enter your meeting ID followed by pound.
Renee Wright, Lakeshore
I think
Legal
that's
Aid,
her.
P86048.
Thank you. Go ahead.
Your Honor, we're asking to have this case dismissed for failure of the plaintiff's attorney to appear.
I'm granting your request. The case is dismissed without prejudice.
Thank you, Your Honor.
You're welcome.
Ms. Morton, can you hear us?
I have her on mute. I'm going to ask her to unmute.
No, that's Sherry Judge, the other Morton.
Oh.
Ms. Morton, can you hear us? She's on the phone. Ms. Morton.
I'm here.
Now I
Okay.
hear you. Thank you. Just a moment. Yes. Okay. Sure, thank you. Recalling the case of Morton versus Warren Burkett, file number 22-2456 LT. One more, ladies. Oh, this is just a signature file though. Okay. Yes, Miss Morton, will you state your full name for the record? One more time.
Morton.
Are you on speakerphone, Miss Morton? If you are on speakerphone, will you turn that off and just speak normally into the phone?
She hung up, Judge.
All right, what I'm going to do is set this matter for hearing. Miss Warren Burkett, will you state your full name for the record?
Precious Warren Burkett.
All right, I'm going to set the matter for an in-person hearing so that we don't have technical difficulties. If it is correct that you were not able to resolve your case today, is that right?
Yes.
Okay,
Don't
I'm going to set
worry.
a date in
She'll
just
be
a few
back.
minutes. Hopefully, Miss Morton will be back audibly.
Her landlord needs to change her battery. Don't worry, Miss Morton will be back. Give her a second, guys.
Do you have a
She's coming.
battery that's going out? Miss
Me?
Burkett? Yeah,
Huh? Yes.
that chirping is a fire alarm battery.
Yeah.
All right.
Josh is ready to nail me if I forget to unmute ever. He has bullets ready in his little phone gun.
All right, the date that I'm looking at is Friday, January 6th at 10 a.m. However, I need to advise you that if your landlord is concerned about damages to the property from water or anything else, that she may end up filing a separate complaint on an emergency basis where we would have.
Judge, were you not paying attention this entire time? She's not filing an emergency complaint. There's no chance she will find that paperwork.
To move that date up.
Okay.
So I would just suggest that if there is a water issue, that you permit your landlord entry in order to deal with it, because you wouldn't
I'm sorry.
You wouldn't want your home damaged by water or anything else if it were you. Yes, is there something you wanted to say?
Yes, I told her about it the day I had the officers come out while the plumbers came. Her plumbers that she has stated to me several times.
Just a minute, I think she's trying to come on. Hello, Miss Morton?
Yeah, I know. I'm just having so much trouble. I'm a senior citizen. I'm not.
We can hear you now. We can hear you now. So what I'm doing, because you were unable to resolve the case, is set up for hearing. And the date that I'm looking at due to the holidays is Friday, January 6th at 10 a.m. in person. So we won't have to deal with these issues with the phone and with Zoom. I indicated to your tenant here, Precious Warren Burkett, that if you suspect that the property is being damaged by water or anything else, you might file a separate complaint on an emergency basis and get a sooner hearing. But the best I can do right now is Friday, January 6th at 10 a.m. She indicated to me, she indicated to me that she has had plumbers in the home. Is that correct?
No, we tried to get him into the home. That's when she called the police when the plumber arrived. And when the plumber arrived, she was not at home. So I said, well, I have a key. And she put some. The plumber.
You're breaking up again. You're breaking up again, ma'am. I don't know if it's your Wi-Fi or what the problem is.
Your Honor, can I finish?
No, that's why we're setting a hearing, so that you'll both have an opportunity to talk and we won't have this interference. I'll be able to hear both of you in court. The court date is January 6th at 10 a.m. at the courthouse.
Write it down. January 6th. At what time?
10 a.m.
At the court.
Yes, ma'am. Thank you.
How do I get emergency service into my home?
You need to consult an attorney. I can't give you legal advice.
She don't have to. She can just set up a date and contact me. They were out here with the police and I let them in, and they told me and her husband that they don't see no water at all, and they left. And that was September 30th, right before she served me a notice to quit the same day. But the police told me to let the plumbers in, and her husband came in with them.
And the plumbers were not able to assess the damage. And also, you said if anybody come up on your porch, you got the right to shoot them.
They came inside with your husband.
Excuse me. Both of you be quiet. Both of you be quiet. I cannot resolve this case today. I will see you on January 6th. Goodbye.
So much.
You're welcome.
Linus, you got me in trouble with everybody. Okay, that makes more sense. That makes more sense. Don't do that, but that's good. Last one, guys. This attorney is humiliated in court a little bit.
Objection?
No objection, Your Honor.
All right, Commissioner Strand, you may continue.
Thank you, Your Honor. James Lee, appearing on behalf of Anthony Brown, who consents to my appearance on his behalf. Is that correct, Mr. Brown?
Yes. All right, and Madam Prosecutor, well, may I have your name, sir, first?
Anthony Paul Brown.
All right, Madam Prosecutor, what is your pleasure at this time?
Your Honor, the people's pleasure would be the people would respectfully ask this court to set a jury trial date.
All right, thank you.
All right. That's all she wants. All she wants is this to go to trial. Poor girl. Josh, here's where we stand. Got the new motor in, bought a new fan, got the new fan in. The motor's there. Now all we have to do, the only thing we have to do is snake the belt. We haven't done that yet. We just gotta snake the belt. That's it.
Thank you.
This is the day for the final pre-trial, and the complainant is not here. So in the absence of the complainant, can you move for dismissal, Your Honor?
All right, thank you. The defense counsel has moved for dismissal on the basis that the complaining witness has not appeared today. Court noting that the complaining witness did not appear on May 17th, 2023, which was the pre-trial conference in this matter. Is there a response from the people as to that motion?
Yes, Your Honor. First, the people are looking to move even in absence of the complainant, and would also respectfully note that this honorable court cannot dismiss this case at a pretrial.
I'm sorry? You said I cannot dismiss the case at pretrial?
It's the people's understanding that just because a complainant did not show up to a pretrial does not mean this case can be dismissed by this court.
Okay, so you're saying that the court can't dismiss the case at pretrial because the witness does not appear after the witness was ordered to appear?
Your Honor, we don't have an official order declaring that a witness needs to appear, and I can still proceed without the witness at this time.
Okay. So the argument is that the people are prepared to proceed, correct?
Yes, Your Honor.
Okay, so we're not having an argument as it relates to the court's authority to manage or maintain a docket through the dismissal of cases in which witnesses were ordered to be present and they're not making an appearance.
Your Honor, may I actually inquire as to that? Why can a case be dismissed if the complainant isn't present? I understand I apologize, Your Honor.
The court has the authority to run its docket and to do so in the most efficient manner as the court sees fit. I know we're not having an argument regarding whether or not a court can schedule cases as it sees fit. Are we, Attorney Solari?
Yes,
I'm personally a bit confused on it, Your Honor, because I've discussed this with my office, and it's not practice from my understanding to dismiss a case just because a complainant was not present at a pretrial.
Where is that the case?
What do you mean, Your Honor? I'm sorry.
I'm saying you said it's not practice. I'm asking you, where is that not the case?
It's again
Go ahead.
Go ahead. Just from speaking with my supervisors, Your Honor, Trish Gerard, Larry King, as well as Susie Tawil, I have expressed to them that we've had an ongoing issue with our complainants not being present and intending to proceed forward. And they have told me that it is not practice and that the case cannot be dismissed at this point, just because the complainant has not been present for the pretrial.
All right, so you're talking about what attorneys have told you. If you're gonna make a statement on the record to the court about what a court can or cannot do, I would like you to do so with some legal authority. That means that you should present a case that says the court can or cannot do whatever you're proposing the court can or cannot do. Okay, so Attorney Solari, I expect to see that in my email by Friday, the close of business. If you're indicating that this court is or has done something incorrect, then I want to make sure that the court is doing it correctly. So I would appreciate the authority that your supervisors or whomever has regarding what a court can or cannot do as it relates to managing its docket. I would appreciate that. That aside, the court is denying the motion to dismiss on today and will set the case for a further final pretrial conference. The court's not yet scheduling this matter for trial. That will be on July the 19th at 9:45 a.m. and that will be via Zoom. Anything further from the people?
No, Your Honor.
If I may, Your Honor?
You may.
Also, on behalf of Mr. Brown, Attorney Anthony Roberts, P76414. I'm not going to go back to the rulings that were just made, Your Honor, but my client is on a tether with curfew provision. Being that this is actually the final pretrial, not a pretrial, this is a final pretrial conference. We would respectfully ask, Your Honor, as it doesn't appear that really anything's happened since the pretrial and this final pretrial, that the court entertain removing the order for the tether and curfew provision at this time and continuing a no contact provision with the expectation of Mr. Brown not to have any contact with the complaint. You understand that?
Yes. Is there any response from the people as it relates to the defendant's motion?
Not at this time, Your Honor.
All right, court will grant the request, court will remove the tether, and court will continue this matter to the 19th of July as stated.
There, she wasn't going to object to that. She's not going to object to anything for another year. Monica, I'm going to tell everybody if they wear a Court Vibes hoodie, the snow will miss us. It'll work. Everybody will buy one just because they believe it.
Anything else?
Your Honor, if I can, just for clarity purposes, because I know the record's going to need to be clear on this issue. If the people are proceeding with the complainant, is it the court's expectation that the complainant should then be there at the July court date?
Well, I'm waiting on the authority from the people as it relates to whether the court can or cannot order witnesses present, whether the court can dismiss cases if those individuals don't show up after they're ordered to be present, or whether the court has to hold a case indefinitely when the people have made zero showing that they're actually able to proceed other than saying, I'm able to proceed. And so that's what I'm waiting for. So I don't have an expectation right now until Attorney Solari or whomever presents this court with the legal authority about what I'm doing wrong or what they're arguing on.
Thank you, Your Honor.
We'll take it from there.
If we could maybe be privy to the court's decision making as the court entertains that issue, then maybe we might bring this matter to the court's attention prior to the July.
So once I receive that authority, then I'll give you all an answer, and that'll be by the close of business on Friday.
Thank you, Your Honor.
All right, thank you.
Just wait.
Is that, I think that's it, right?
So I've not, a pretrial conference, okay, for probable cause hearing, an arraignment or whatever, no, probable cause hearing, then yeah, you probably need the complaining witness there. I've not heard of them demanding a witness at a pretrial conference. That being said, you can't tell the judge you can't dismiss the case. You can't. And we've seen it a billion times. The prosecutor comes in and says, are you ready to proceed? And they say, yes, I'm ready to proceed. They don't say, yes, I'm ready to proceed and I got the witness here. They don't say that. So I think they're both right. And I think they both took the wrong stance during that whole court, that whole hearing that made everything worse. They just said the wrong words in the wrong order at the wrong time, which I do all of the time. I start talking on this camera before I even touch coffee in the morning. If you're here for court, court's over. Thank you so much for coming out. I appreciate it. Let's talk about the storm, guys. Guys, we're about to get hit with a storm. This is supposed to be a big one, or it's going to be nothing for me. For me in Pennsylvania, the way it's coming up. So I'm near Philadelphia. I'm not in Philadelphia. You know, I could hop in my car and get there, you know, fairly quickly. So I'm just going to talk about Philadelphia because it's easier for people to understand. So for Philadelphia and us up here, all right, so the storm's coming, and then we don't know. It's either going to shift or not shift. And we do not know what it's going to do yet. But you have a better chance, Mel. You have a better chance of it shifting. But the bad part about that is you're more prepared. You get heavier. Okay, because you're closer to the whole Canada thing. And the Arctic, you guys get hit worse than we do in Pittsburgh. But this one is coming from the other way. So it's supposed to be, right now, we are 12 to 18 inches in Lancaster where I am. I don't know. I know Texas is not prepared. We all know Texas is absolutely not prepared. Their energy, their electricity grid, horrid. Because, you know, they're not part of the rest of the country. Well, Josh, I'm not shoveling. I told them I have a small chance while my job is down to get my hand in perfect working order. I am not going to mess it up by shoveling. This is the first time. I'm not going to power through. I'm not going to pretend I got this. I'm not going, no, I'm thinking about me right now. And if I want my hand to work for the rest of my life the way I want it to work, I have to get this tendon to calm down just a little bit more. Just a little bit more. So, no, I'm not. I did try to open. I make them open everything. Open this for me. Open this for me. Carry this tiny little thing for me. I don't want to carry it. I mean, I still carry. The thing is, my left hand now is starting to object because I'm using it for everything. But everybody have groceries, blankets, download some YouTube videos, guys. You know, get everything ready. Get a book. Read the Harry Potter series. They're really good. They really are really good books. They really are. They drag you right into it and hold you there. What else can we do? I don't know if we want to do a stream. I don't know. Like I have yesterday, I watched this court. It sucked me in. I couldn't stop watching it. It's not anything I could play here because it was boring lawyer talk. And I was enthralled the entire time. So maybe, I don't know, maybe if everybody gets bored, I will do it like a members only, because that'll tear my numbers down even more if I show that on the regular live stream. But, oh, that's right, you guys might not have internet. So a live stream will not help you if you don't have internet. We used to shovel snow for a few bucks as a kids too, but my kids won't do that. They won't get out there and make me some money. I should get flyers for Anthony. I should get flyers for him. He can go shovel some snow for money. How do you know he's going to stream today? Do you know something we don't know? I'll get his whole docket if I can. Bobby, you should just try reading a little bit of Harry Potter. I'm telling you, it's a good story. I know the movies and the blah 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 and And the fan fiction, although some of that fan fiction is really good, but it's not. It's a great story. It just really is. The way she writes, I mean, I don't particularly approve of her as a human being, but she did write a good story. There's so many good parts. Okay, if you read the books, there comes this point in the books where they're at the Yule Ball and all of a sudden Hermione is with Crumb. Seriously, what? I screamed when I read that. That was a good part. I had no idea. That came straight from left field. But Monica, if you go to Australia, I'll go to Australia. See? Monica's never going to Australia. I told you if you're here for court, you can leave, Belle. It is nostalgic. Belle, did you call him? Belle, I told you at the beginning of the stream to call Judge Fleischer. Did you call him? Come on. Call him. I wanted you to call him at 4:30, which would have been 3:30 his time. And tell him to stream today. I'm not going to do it. I wouldn't even call Vic. Michael came to OJ yesterday. Vic's husband, Michael Burnell. He was in OJ yesterday. That was really exciting. I love when he comes. So, back when Judge Fleischer first started streaming on YouTube. Well, first it was me, Phil, and Colin. We were mods. That didn't work out. So then Victoria's husband became a mod with me on Judge Fleischer's channel. So I call him my co-worker. No, Bill, be nice. We love Judge Fleischer. Don't call him anything bad. So yeah, it was me and Michael, and we were the mods. And back then, the eyes were glued to that chat. Like, I didn't even use the ladies' room when he was on. My eyes were glued to that chat because there was no way I was letting a message get through. None. Zero chance in the world a bad message was getting through. Not on my watch. And there were plenty. Jeez. People said the worst things. You know what we don't do in my chat? Delete messages. Hardly, never, ever, ever. We did, but those people are gone now. The people that we had to delete the most messages from, they're gone. They didn't make it. They couldn't hang. But we tried so hard. Our mod team, we got yelled at every single day for being mean to people, for, being power hungry, they called us. And we were like, we have to delete these messages. We cannot leave these messages in a court chat. You cannot say something like that in a court chat. It's a courtroom. You're in a courtroom. Yes, Bren, you're still here, but we don't delete your messages often. You don't say things like that. Nobody here does. This chat is just a unicorn in YouTube land. People don't come and bitch and moan and say inappropriate things. You guys come every day and you guys just say nice things to each other and support each other and are happy for each other. It's a unicorn. It's really not like that in a lot of other chats. It's just not. People are just mean. They don't know it and they don't think they're mean, but they are. I love when we talk about off-topic things, Mel. I love it just so much. Someone timed Zach out for saying that. Don't. Zach, it was tempting. We did time people out by accident plenty of times. It happens. So when you go to delete a message, we ban people all the time by accident too. The chat was moving so fast that when you would go to delete a bad message, the chat would pop it up right at the second where your finger was about to push a button. And boom, you would ban someone else by accident. All right, I'm going to be watching Discord today to see if you guys need anything. See if there's anybody out there who's about to get hit by the storm and needs help. Seriously, if you need help, we can fix it now. No one's going to be able to buy you a generator, which would be nice. But if you need, candles, a blanket, some bread, we can fix it right now before the storm hits. All you have to do is type in Discord, listen, I don't have any food for this storm. And, we'll try to do anything we can. Just let us know so we know to help. Don't be prideful before this one storm. Okay? Brandon, you get nothing. I can't ship to Australia. It costs so much money, and you're not about to get hit by a storm. You're about to get hit with, 41 degrees Celsius? I tried really hard, friend. I'm a dumb American, and I don't know what 100 is for you guys. Zach, you flew to Florida. Quitter. I'm not looking out for my neighbors, V. I can't stand them. Well, I like, some of them I like. Some of them, it is, Eileen, it is. Hopefully we're nice. And not, mean. There's nobody in this chat that I roll my eyes when I see pop in. It's like, oh, God. Now what are they going to say? Now what are they going to do? Nobody. Oh, I was 41. Oh, 50. I don't have time to Google it. I wonder how many 41 is. Bill, send me $5,000 so I can send Brent $100. That sounds like a deal. You've been hit by lightning? Wait, maybe I read something wrong. Amy, did you get hit by lightning? Oh, I was so close, Brent. I was so close. Maybe she could come and steal all my snow. It's not too hot. I don't know. No one was nice in Judge Fleischer's chat. Every day, Eileen, every day, all we did was delete messages. You guys didn't see, we tried to be as fast as we could so no one would see them, but man, that was rough. That was the roughing my job I ever did. I know it was very lovely out yesterday. Bobby, get me some coffee too. Okay, Amy, that's good. I didn't want you to get hit by lightning. That would have really sucked. A lot, I hear. I don't know. I think we'll be fine here in Pennsylvania. We know what to do. That's a good idea, JK. That's a good idea. I think maybe, Eileen, I don't know this, okay? I'm not telling you this is going to happen. I hope you understand, guys. Guys, I'm not saying this is going to happen. Judge Fleischer did stream the other day, which means he's not completely against all live streaming. He just needs to figure out a way to do it the way he wants it done. And I'm hoping, and I don't know, but I'm hoping that YouTube will come back. He will move back towards YouTube. And there are just so many other Texas judges that are. And Judge Boyd. He can just talk to Judge Boyd How do you handle this? How do you handle that? So I think he's a step closer. That doesn't mean anything. It doesn't mean he's there. I'm not telling you he's going to be on YouTube today. He could be, though. You never know. It's up to him.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain. 'Cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.
Because I didn't forget, Josh. I didn't forget to unmute. I think I must have touched my keyboard and accidentally muted myself. So that is not a forgot to mute screenshot situation. That was just a tiny accident.